Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. The terms of the call have been declared and informed to you as you logged into the conference. Um, Today is December 3rd. I'll go over the frequently asked questions that have been posted first, then any follow-up questions on the frequently asked questions, then the other posted questions, and finally, if time permits, new questions. Let's get started with the frequently asked questions. Um, and by the way, my Twitter feed is on, so if you need to tweet to me something, I'll try to keep an eye on that as well. Going back to our first frequently asked question, how to calculate dates from visa bulletin. So basically, there are three different uh, considerations when you talk about dates and times it takes for green cards to be processed. Okay, three different things you need to worry about. Um, Number one is something called priority date. Priority date is the date when your green card visa numbers are available. It means that you are entitled to get your green card. It doesn't mean you're going to get it right away, but it means you're at that stage where you're going to get your green card or about to get your green card. So priority date usually is the date on which your application was started. In case of family-based petitions, priority date is when I-130 was filed. I-130 was filed. Employment-based cases based upon PERM, when PERM was filed. Employment-based cases where PERM is not involved, uh, direct I-140 is involved, such as national interest waivers, EB1s. That's priority date is the date you file the I-140. Okay, so it all depends. Your priority date depends upon the date your case was started. That's one thing you've got to worry about. So when you go to Visa Bulletin, which is a monthly publication of the US Department of State, it tells you what visa dates are expected to be current, or in other words, where the queue is for the next month. So in December, they will issue predictions for January. In January, they'll issue predictions for February. Then, on top of that, you have to worry about processing times. Sometimes, for example, in US citizens' cases, there is no priority date backup. Dates are immediately current. For example, spouse of a US citizen, parent of a US citizen, minor unmarried child of a US citizen. These are all beyond, or they're called immediate relative cases. There are no priority dates issues there. In those cases, you have to worry only about the processing times. So when you file the form takes a certain amount of time to process. That's a separate set of dates. Okay. And now a new concept has been started a couple of months ago. I think it's called final action or something like that. If you go to USCIS website, it tells you if you are in the United States, this is the date when you can file your last step of the green card process. If you are outside the USA, this is the date when you can expect to receive further paperwork from the consulate. It doesn't mean you're going to get your green card right away, but it means you're eligible or you're close to getting it. Let's put it that way. Okay. So the final action date, etc., is just the date which, if you're outside the USA, tells you you're getting close. If you're inside the USA, it allows you to file your 485, which is the last step of the green card process. Now, the question here from ALBGC is, how can I calculate my sister's possible visa interview? Now, here is another variable. How much time is it taking at that consulate to schedule interviews? Some consulates are very heavily overworked. Some consulates are relatively less worked. So that's the fourth variable. First variable was priority date. Second variable is processing times. Third variable is final action dates, which is also part of the visa bulletin, a slightly different table. And the fourth thing is local processing times. Okay. So she has already submitted her documents to NVC. When she was waiting for the visa date, she turned 21 and moved to family 2B category. When do you think it'll be the next visa date? If you're, first of all, if her priority date is current, normally, and you said NVC has already, taken the documents. Normally within a few months, probably less than 6 months, at the visa bulletin, the final action table tells you approximately when she can expect her final documents. Once the other parent becomes citizen in the USA, would it be helpful to submit another petition for her? You can file multiple cases for the same individual. That is not a problem, as long as you see some gain in it, depending upon the country she was born in filing through two simultaneous categories. You can certainly do that. There's no harm in that. You have any follow-up questions on this? Press *5. Only follow-up questions on this issue I discussed. Nothing new. Press *5 on your phone if you have follow-up questions on this. Okay, let me go on to the next frequently asked question. Very interesting question. What is I-485 Preadjudication? Okay, so you are at the last step of the green card process. Your priority dates became current. You filed the 485. Then the priority dates slipped back 2 years. At this time, USCIS has two choices. They can either put your file in their filing cabinet and forget about the case until the priority dates become current again, or they can sit down and say, look, we have time. Let's go over the case, adjudicate all the details, decide that the case is completely qualified to receive a green card. So we pre-adjudicate, decide that the person is entitled to their green card, make a note on the file. If we need some documents, we send an RFE, get the documents. So when the priority dates become current again, all we have to do is issue the green card. That's pre-adjudication. Another frequently asked question is, how soon must I join my future green card employer? And the answer is, there really is no rule of thumb, but I would say within a commercially reasonable period of time. A few months, maybe 3, 4, 5 months after approval of the green card, you should join the future green card employer. If in your particular case that appears to be a requirement, sometimes it may not be a requirement because of AC-21. Because remember, AC-21 portability is available even in future green card employer cases. Situation for RD is, I have my EB2 India priority date 2008. 485 was filed October 2014. Future green card application. There's an RFE for expired medical forms. So, is it safe to assume that my application has been pre-adjudicated? I don't know the answer to that question. And I don't think that USCIS has any particular method of informing you. You can try calling the customer service. We were not usually able to find out. I haven't tested this hypothesis lately, but at least as of a year ago, we were not able to find out if the case had been pre-adjudicated, simply because the frontline people who answer your calls don't have that information on their computer screen. If USCIS has changed their screen and added this information, you can try calling them, but I don't think you can assume that. I explained what pre-adjudication means. I explained the time frame for joining the employer. Do I think you'll be called for an interview? I don't think that is necessary. Just because you have a future employer case does not mean that you will necessarily be called for an interview in the local office. Anybody has any follow-up questions on this issue I just discussed? Nothing new. Press *5. Okay. No new questions. Okay, next is from Gen1234, Immigration Implications of Crime, Petty Offense Exception, Admissions and Convictions, 212D3 and other waivers. I'm going to talk about these issues one by one, and because we have a limited time, usually these issues can take a couple of hours to go over, But I'll give you a quick overview so that you kind of understand where things are. And if you need to get further information for your particular case, at least you'll be sensitive to some of the issues involved. First of all, not every crime leads to serious consequences in USA. Okay, there are two kinds of crimes: misdemeanors, which are small crimes, punishment is typically less than a year, or felonies, where the punishment is a year or more. Those are more serious crimes. We look at a couple of things. In immigration law, we look at, first of all, is the crime a misdemeanor, or actually, let us change that. Is the crime a crime of moral turpitude or not? If a crime is not of moral turpitude, we don't really have to, I believe that it has actually no consequences unless it is a drug offense or one of the other offenses that have been prohibited by law. But usually, I can't think of, there are crimes that I can't think of examples off the top of my head that are, even though they are crimes, but they are not considered to involve moral turpitude. Moral turpitude simply means that you are doing something which is which reflects on your poor moral character. Okay, so if there are crimes of moral turpitude, we then go to the next step: is it a misdemeanor or a felony? If it's a felony, we almost certainly have a problem. It could lead to deportation, non-admission, and then you would need a waiver of some kind. And that will bring me to 212D3 waiver in a minute. And waivers are usually available for green card only for family-based reasons. You can't get a waiver just because you want to come to USA. So in an employment-based case, and you have a felony conviction for a moral turpitudinous crime, you will not be able to come to USA. Okay. And remember, the rules are different for deportation, what is called removal, and admission. So when you try to enter, you could be subject to slightly different laws. Sometimes you are in USA and you think I'm safe because your lawyer told you, okay, you're not going to get deported, but when you come back, they won't let you in, and now you have to go back. The reason is the rules for admission are different. This is a very complex area of the law. Okay, so we have looked at felonies. What if I'm convicted of a misdemeanor involving moral turpitude? Then we look at, first of all, how many misdemeanor convictions do you have? If you have multiple convictions, that itself is a ground for deportation, removal, as well as no admission. Okay, but if you have only one offense and it's a misdemeanor, and the actual punishment imposed was less than 6 months, you are covered by something called petty offense exception, which says we forgive you entirely as long as it is just a single misdemeanor. Okay. Now, the rules under immigration law and the rules under criminal law for conviction are very different. Sometimes you will have a criminal lawyer, criminal defense counsel, he'll tell you, oh, this is not a conviction. Well, it may not be a conviction under criminal law, it is a conviction under immigration law. Any kind of plea bargain you set up with the government where you are admitting directly or indirectly that you committed the crime would be considered in all probability to be a conviction under immigration law. So be careful, make sure if you're in that situation, you have discussed this issue in detail with an immigration lawyer in addition to your criminal defense counsel. Okay, now what is a 212D3 waiver? 212D3 waiver says if you got the kind of conviction where you cannot come back, we can let you in on a temporary basis for a non-immigrant visa. 212D3 applies only to non-immigrant visas. And the situation has been a little uncertain, especially for Canadians. I think there's a certain time frame for which you can get it, or for one visit you can get it. So let's go to Gen 1234. She says, I have a Canadian student visa. I have a B1, B2 visa. Then there was a theft charge of under 5,000. The charge goes withdrawn diversion. Now, normally diversion means some kind of a plea bargain has been made. Okay. So when I went to US Embassy for visa renewal this October, the officer asked me about the charge. I said I did it on purpose, and I regret it. He rejected my Class B visa and gave me a pink paper which says the denial is under section 214B, which is basically just a denial that you don't have strong ties for your home country and you could become an immigrant. I found that my admission of the offense will make me inadmissible to enter USA as a moral turpitude. But the officer did not say I need waiver to enter the US. So my question is, does this mean that their denial is not based on the crime of moral turpitude? That is correct, because they denied it based upon their ability or their inability to verify that you will come back. This is a relatively minor denial. I will marry a Canadian citizen next year. Would it be a strong tie? Definitely. I think that would make it a much stronger tie, and you can try again. And you might be covered by, I don't know the whole case, but you might be covered by petty offense exception. So one crime of moral turpitude, if it is just a misdemeanor, punishable by less than a year in maximum sentence, an actual sentence imposed, whether suspended or actually served, was less than 6 months. I think I've got the factors all right. But look up petty offense exception. That should petty. It's there in my frequently asked question header. It tells you, I'll just highlight it for people who are watching the screen. So petty offense exception. Okay. Another question is, I have an offer from a company for summer internship, J1 visa. I think if you are covered by petty offense exception, Jen, then even J1 is not affected. But the problem is the 214B denial affects your J1. If you have a 214B denial, it will bar your entry for J1, F1, B1, B2. It will not bar your entry for H1 or L1. Okay. I suspect the officer realized that you were covered by petty offense exception. Any follow-up questions on what I have just discussed? Press *5. Any follow-up questions? Please press *5. Okay. Let's go to the, okay, there's one raised hand. Let's go back. All right. Go ahead, I can hear you.
Okay. I have come here in
Okay, hang on. I'm stopping you. Sorry, I'm muting you. I clearly said only follow-up questions. No new questions. Only follow-up questions on crimes, 212D3 waivers, etc. No new questions, please. Okay, no follow-ups. Let me go on to the next. We'll come to new questions if we have time at the end. I have to answer first the frequently asked questions and other posted questions, then time permitted new questions. Okay, let's go on to the next frequently asked question. Naturalization delays. So Day wants to know what can we do about naturalization delays? But typically there is a law on the books that allows you to file a lawsuit against the government if there has been unreasonable delay and there's a certain time period provided. I don't remember all the details off the top of my head. Is it 180 days or something like that? But courts have said, some courts have said, not all, so it depends upon where you are also. You should talk with a local lawyer who knows this issue and see if they can figure out for you. Some courts have said that time from which we start counting the delay does not begin until the security clearances are received. Okay, so one or two courts might have said, no, the time begins, that it includes the security clearance delays, and you've got to adjudicate the case within that time. Some other courts have said no, and in fact, many other courts have said no. So let's look at what your situation is. Lexington, Kentucky, N400. Wife got her passport done. She's got her interview. Okay. They said due to workload, they were holding his case. Took an info pass, and they said the case is with National Service Center. They're waiting for security clearance. Exactly. Is there a time limit to security clearance? Look, I think I have actually done a lot of frequently asked questions on the writ of mandamus for delays. I normally don't recommend it. What I do recommend is please get together with your congressman's office. Call your congressman, tell them to follow up the case. Let's see what they say. Write back to me, let me know here on the conference calls what they say. And if they can resolve it, that will be the quickest and zero cost method for you. Follow-up questions on this issue. No new questions, please. Follow-up questions, press *5. Okay. Yes, Kentucky, go ahead, please, Kentucky.
Yeah, so I have now, like it's been more than 10 months. So I'm sure I'll thank your last congressman and I'll write him a letter. But how long do you think generally it takes? Like once the
No,
clearance,
that's a little extraordinary. And you don't ask, please don't answer this question. But normally, what happens is, if your name, I don't want to know your name, keep it confidential. If your name involves something which is a common name and it can be confused with other names, usually in the security clearance, when such a situation happens, somebody has to manually verify who you are. And that can take a long time. Okay. But 10 months, I think, is unreasonable. 4 or 5 months, 6 months extra, okay, I can understand. I think let's have you go to the congressman's office and see what they can do for you. And let me know in a couple of weeks when we talk again. If it's not working out, I may recommend filing a lawsuit. Okay?
Okay, and the lawsuit is that writ of mandamus, right?
Actually, I don't know if it is writ of mandamus. I don't remember. Writ of mandamus is simply an order of the court which says, Mr. USCIS, you have a duty to adjudicate something. You have unreasonably delayed or withheld that duty. You must now exercise that duty. However, this could be a statutory cause of action because there is a provision in the Immigration and Nationality Act that allows you to file lawsuit against a particular delay. I don't recall if it is a writ of mandamus or it's just a action under a statutory cause of action. It doesn't matter. That's just a technical matter. You don't need to be involved with it. It's sort of like when you get on the internet, you don't need to know whether your server is running Red Hat or whether it is running, IBM's operating system. That's something you don't need to worry about. All you need to know is my HTML feed coming through. So it's sort of the same thing. The idea is the same. It doesn't matter what kind of action is filed. Okay?
Okay.
Good luck, sir.
Thank you.
You're welcome.
Sure, thanks.
Okay. Let's go to the next frequently asked question. This is another one that comes up quite often. So in many countries, especially India, Pakistan, Bangladesh, it can happen that the birth occurred much earlier, but the registration of the birth was done much later. Because remember, it was not the law that you have to register every birth. It was a voluntary action. So if a child was born in 1980 or 1970, you registered the birth in 2015 because that's when you needed to get the green card. Now, those are not acceptable registration. What you should do in those cases is get a letter from the municipal corporation or local government that says, before this was registered, there was no other registration. So like a non-availability before the registration. Along with that, get 2 affidavits from your parents or other people who were alive when you were born, and that will take care of it. Okay. Secondary evidence becomes acceptable only when you can't get non-availability from the municipal corporation, and that's a much more complicated area. I think you should get the non-availability, which can be just a letter from the municipal corporation saying, we hereby confirm for the record that before this date, when this birth was registered, there was no other registration for this birth or this person. And that gives you the non-availability that you need. Any questions on this? Press *5. No new questions? Any follow-ups on this? *5. Okay, there is, let's see, one follow-up question. Canada, go ahead, Canada.
Hello, sir. Good afternoon.
Good
Thank you to sir. Sir, I have a current situation. I applied 2007 for my birth certificate for 485, but I got a birth certificate from affidavit, and I got non-availability certificate from the consulate. That is valid or no?
Probably not. I would want you to get a non-availability from the municipal corporation of the city where you were born and two affidavits.
I'm born in Bombay. Yeah,
Ah.
I'm born in Bombay. They don't give second certificate. That's why I go to the travel register, and
No.
I got a certificate from there.
Look, you need to get that non-availability certificate. I know it for a fact that Mumbai will give you a non-availability certificate. They'll tell you, we don't have a record of this.
Okay. Thank
All
you
right.
so much.
You're welcome. Okay, there's one more question on birth certificates. California, go ahead, please. California.
Yeah, I received my birth certificate, which I stated in my question that I have received. I actually got a non-availability certificate, and then we applied in the court by submitting that non-availability code and the proof, and then we got the birth certificate from the municipal authority, which states the hospital name and as well as the city. But my passport has just the city.
That's okay.
And,
That's okay. If you have the non-availability, just get two affidavits. They can come from your parents.
then the non-availability certificate, which has been submitted in the court to get the original birth certificate now. So now I have got the original birth certificate issued by the municipal authority.
Yeah, but when was the birth registered?
It is registered in 2015.
That's the problem. Birth should have been registered when you were born. Okay.
Okay.
So
what should I?
Look, here's what you should do. You need to really sit down with your lawyers. They can actually prepare an affidavit from you, giving all the facts of what has happened in your case. See if that flies along with the two affidavits, because you've gone through the court proceedings, you've done a lot. See if that flies for you. If not, in the meantime, get a copy of that non-availability certificate and also submit that along with, whenever you can, along with the two birth affidavits or the affidavits from your uncles.
I have a copy of that non-availability certificate. But
that's all you need. You just need a copy. You don't need the original. Government can ask for the original, but you can just submit a copy for now. If I were you,
the copy is pretty enough.
If I were you, I would take kind of a shotgun approach and submit everything.
Okay.
Because as long as the evidence is not mutually inconsistent, you can submit everything. Your records, your hospital records, if you have them, school and college certificates, even though no birthplace is mentioned, they mention your date of birth. So whatever you have, submit all of it.
Okay. So I don't have the hospital records.
That's okay.
That's one.
That's all right. That's okay. You don't need it.
Okay.
My guess is you're going to be okay. As long as there's no inconsistency in this evidence, you'll be fine.
Oh, okay.
All right. Good luck. Okay. Let's go on to the next frequently asked question. This is also comes up very frequently. H-1 status and Family Medical Leave Act. So let's say an H-1 holder gets pregnant, and by the way, congratulations. They want to take a medical leave or maternity leave. How long is that leave valid? What is the maximum time I can be on that leave? Is she considered to be in H-1 status? And the answer is, well, first of all, I just Googled it actually. FMLA, hang on one second, I've got a tweet from somebody. Oh no, that's just a follower. Okay. FMLA allows up to 12 weeks of guaranteed employment kind of leave in 12-month period. Okay. Now, it can be more or less also depending upon the state law. And remember, if there's a medical need, for example, if the doctor says, look, you have some medical reasons, you should stay an extra 6 weeks, you will still be in status. So if it is medically necessary, So normal is up to 12 weeks, less or more depending upon the state law. Not less, I guess more according to the state law. If you need even more than that, then there has to be a medical reason. And all this time, you will be considered to be in status. I actually quote that example quite frequently. A good friend's sister was laid up for over 1 year, very severely sick, and she was on H1. When we converted her to H4, we produced evidence that she had been hospitalized and all the medical bills, etc. So they gave her H4 status without having to leave USA, which means even 1 year off the payroll was considered to be in status where there was sufficient reason for it. Okay. Anybody has a follow-up questions on question on Family Medical Leave Act? Okay, one. All right, let's get to that. Texas, go ahead, please. Texas. Hello, go ahead. You have your hand up.
Roger, it's good afternoon.
Yeah, I can hear you.
Yeah, I'm talking on behalf of my wife. Right now, my wife in US, and she is valid stamp H4 visa until next year. And I have also applied H1B this year.
Okay, hang on 1 second. I'm sorry, I have to cut you off. I'm only dealing with issues related to Family Medical Leave Act. No new questions. That'll come later if we have time. Okay. No questions on Family Medical Leave Act. All right. By the way, this gentleman who had the Family Medical Leave Act question, he said, is it possible to conduct these conference calls during weekend? Guys, I have given it some thought, and it becomes very difficult for me to predict my weekend. I don't want to be held down to a schedule over the weekend. But you know what I might do, and I'm thinking about this, I've been thinking about this for a while. I can probably have some kind of a Google Hangout where whenever I'm available, I can send a message out and see whoever wants to ask any questions when I have time over the weekends. They can immediately log in or do a Google Hangout. But it's not possible for me to schedule a regular time over the weekends. Sorry. Okay. So now let's go back to the normal questions, which are not frequently asked questions. Let's see. The first one is from AP2605. I have an H1B from employer A, good till 2016. In 2014, I went to India. I have a valid visa stamp till 2016. But then I changed to H4. Now I want to change back to H1 with the same employer. Can I use the same visa? And the answer is, I think so. In my view, you can use the same visa stamp. And if you want to be really, really paranoid, you can always send an email to the consulate which stamped the visa and ask them the same question you're asking me. My guess is you are okay to use the same visa. Can they start to do the H1 process if I'm in India? I would not know for sure if that's the right thing to do. Let's analyze it. You're on H4, but you have an H1 visa stamp. You go to India, the process. I think that's okay, but I would prefer that you get the H1 in hand and then travel and come back on H1 visa. Follow-up questions on this question? No new questions, please. Follow-up questions on this question? *5. Press *5 on your phone. Okay, none. Let's go on to the next one. Frequently asked vaccination. Somebody had a question on vaccination. If you go to the last posting on this thread, you will see that I have given you a link. If you expand this, it tells you exactly what vaccinations are required. And here is the link right on top. I said this page has all the requirements, and it tells you exactly what you need to get vaccinated for. Any questions on vaccinations? *5. Okay. Let's see. Where are you? Ohio. Go ahead, Ohio. Just for one moment, I mean, it's interesting. Every question I have answered has been from a different state, and I always get a kick out of it. In front of me right now, I have Texas, Georgia, Denver. This is just part of the screen. Denver, New Jersey, Ontario, Canada, Tennessee. Amazing. Georgia, you guys are from all over. This one is from Ohio. Ohio, go ahead, please.
Sure. Thanks, Rajiv, for entertaining my question.
Of course.
So, Rajiv, we filed our 485, but during the time my wife was pregnant and her TB result came out positive.
Right, right.
So what should we do? We still went ahead and filed the 485 application.
Yeah, that's fine. What you should do is you should wait for the RFE. There will be an RFE on this, and they will tell you that they need a chest X-ray. Okay. When she's gonna have a baby, they don't do a chest X-ray. Basically, they want to find out that the TB is not active. By the way, in India, I would say a very large percentage of people coming from India test positive for TB. Part of it is because we have been inoculated for TB when we were young. Okay, so all of these can be false positive. Don't let it worry you. This is a commonly encountered issue. Let's take the worst case scenario. I mean, she should be tested otherwise, just for your own satisfaction. But for immigration purposes, even if she has TB, and God forbid that she does, after a few weeks of antibiotics, she can still get her green card, no problem.
Okay.
All right.
Thanks for understanding.
Good luck.
Sure. I appreciate it.
You're welcome.
Thank you.
Okay, I know it's kind of scary, guys, but this is not something you need to worry too much about. We are only concerned about two kinds of things: something that can be passed on to somebody else, in other words, contagious diseases, or diseases such as schizophrenia, which is uncontrolled and could lead to harm to the person or property of other people. Okay, so normally everything else can be managed, and even those can be managed if certain precautions are taken. Okay, where was I? Birth certificates. I'm a little lost. Let me find out. Somehow I got turned around. Okay, here is. Oh yeah. I've had to move my I went out of series because I had to go to the last page. Okay, Janus 99 wants to know, does it cost to revoke an I-140? The answer is no. There is no immigration fees for any revocation. H1, I-140, it just takes a letter. And USCIS will not inform you, but the below link that you have given may give you the most recent information, it may not. These are not 100% reliable. As far as I know, they are still a little iffy. The online web statuses are still iffy. I don't know if this is accurate or not. *5 if you have a follow-up question. *5. But once again, I repeat, it costs nothing to revoke an I-140. No follow-ups. Let's go on. MKB3. Guys, it looks like I'm going to have enough time for new questions, so no worries. My wife has applied for change of status from H1 to H4 and EAD 3 months ago. No updates from USCIS. She's in current maternity leave for last 3 months. Will she be out of status if change of status is denied and employer revokes the H-1B visa? Yes. Because if she's gone beyond the normal maternity leave and there's no legally sufficient excuse for it, she would be out of status. Does she need to wait for travel until the change of status comes? Well, if she travels while the change of status is pending, the change of status is considered to be abandoned. Okay, I don't think you can use the same EAD. This is my guess. I think you would have to reapply for the EAD when she comes back after H-4 stamping. Okay, a spouse's client letter is not required for H-4 stamping at this time, but government, the consulate can ask for anything they want. Normally, it is not a part of their legal requirements. *5 if you have a follow-up question. *5. Okay. This one is also from Texas. Texas, go ahead, please.
Hi, good afternoon, sir. I have applied my change of status from H1 to H4 this week, but approving it will take up to 2 to 3 months. In the meanwhile, how to maintain H1B status up to that, or
Okay, this is the new question. You're gonna have to wait. Please, guys, maybe I'm not making myself clear. You need to ask new questions only when I tell you to. Right now, we are just doing follow-ups. New Jersey, go ahead. New Jersey, you have a question, please. Go ahead.
Yeah, thank you so much, Rajiv, for the community service.
Of course.
It's question number 8, the same question.
Gigi.
So my question is, what's the best way to handle this situation? My wife doesn't want to work now. You know, the baby is small. She need to take care of the baby, and she's on H1 at this moment.
Hang on. Let's just look at your case real quickly again. When does her maternity leave expire?
It's 3 months. You know, she has completed 3 months now.
Okay. Is there a medical reason we could get for another 2 or 3 weeks? Because what I'm thinking is, hang on, have you applied for change of status already?
Sorry?
Oh, you actually already applied for change of status from H1 to H4, right?
Yeah.
Oh,
they've already applied change of status.
No, then there is no problem. She does not have to be on H1. Once you apply for change of status, you are in authorized period of stay. And she applied before she ran out of her FMLA, so she's fine.
Okay, even though the employer revoked H1, in that case, she is also fine.
Her employer, right? Not your employer.
No, for her actually.
That is not a problem. If the H1 was, when was the H1 revoked? Before change of status or after change of status?
No, right now, she has applied it, in the status only.
Okay.
It was not revoked.
If on the date USCIS received her change of status request to H4, her H1 was not yet revoked, her status was protected by Family Medical Leave Act. Therefore, she is safe even if the H1 is revoked.
Okay.
So no worries. And also, hang on. I want to add one more point before I forget. Having an EAD gives you the right and the option to work, but not the obligation. So if she gets the EAD, she can put it on the shelf and not work if she doesn't want.
Okay, that's good. One question, after 2 months, our attorney raised the SR, and USCIS rejected the SR, saying that they cannot expedite the case. So, do you think that we need to raise the SR now after 3 months?
If it is beyond their normal processing time, sure.
So, is any time period for that? Means after 3 months, they will accept the SR?
No. There is only a time period given for the processing of the case. If your case goes over that processing time, you can raise a service request.
Okay.
All right.
Okay. The last question is, on the EAD, right? Do they provide any start date, something like that? I'm hearing, people post something in the forum. So that start date will be the approval date, or that start date is different from the approval date?
I'm sorry, I didn't understand that question. Can you repeat it?
I hear that in the forum that on EAD, they put some start date, so that the EAD will be active from that date. So my question is, that date is the approval date, or is it the different date than approval?
It is usually, there are some exceptions possible. It is usually the date on which the EAD was approved. Okay.
Good
luck.
Sounds good.
All right.
Sure. Thank you so much, sir.
You're welcome. Bye-bye. Okay, guys, I have another hand up. Unless it is a follow-up on this question, please put it down. I'm not answering new questions yet. Press *5 again if you have a new question, because new question time is not right now. Only follow-ups. I have 2 new raised hands. There are no new questions. I'm not answering new questions. Press *5 again if you have a new question. I'm not going to answer new questions. I'm only answering questions about change of status from H4, from H1 to H4, maternity leave, and EAD. those three things. All right, let me see. Texas, go ahead, please. Texas. Texas.
Hello.
Yes, ma'am.
Hello.
Ma'am, I can hear you.
Yeah, right now I am in H1B and I am planning to change the status from H1 to H4.
Okay.
Suppose today I filed the change of status from H1 to H4. From today onwards, my status is H4 or H1.
Okay. This is a very good question and a very important distinction to remember. Okay. First of all, I don't care when you filed it. It's when USCIS received it. That is the important point. Okay. So let us say you are working at the client site, you're getting paid, or working in-house getting paid, and you applied for change of status to H4. Your application was received by USCIS today. From today onwards, you can sit at home and not work anymore if you want. You will be what is called authorized period of stay. You are not in status, but you're not illegal. You can stay and wait. However, if you want to continue working on H1, you can continue working on H1 until the H4 is actually decided. So until the H4 is decided, you are still on H1 if you want to be. If you don't want to be, after USCIS receives the application, you can sit at home. Okay?
Okay. Then one more question. Still I have to maintain H1B status until the H4 is approved?
You do not have to.
Okay.
Okay?
Okay, sir. Thank you.
You're welcome. Okay. Once again, guys, I remind you, I'm not answering new questions, only change of status EAD, H4 EAD questions, please. This one is also from Texas. Texas, go ahead. Texas, go ahead. Okay. And there's another one from California. No new questions, only follow-ups. Go ahead, California.
Can you hear me? So my question is that if, I may lose my job. So
okay, hang on. I'm sorry. I don't know which language to explain this in. No new questions, folks. No new questions right now. I'll come to new questions after I finish this round. Can I do, next question is B. Sundar. Can I do group appointments for two different visa categories? For example, H1 for me, F1 for my spouse. The answer is that depends upon the local consulate where you are applying. So I think you have to go through, I don't know if it is the national system now, I've kind of forgotten. I don't get into this level of detail with our team takes care of the rest of the stuff. I just do the basic or the advanced legal stuff. So I don't remember, but heck, as far as I know, it's not something that you should not be able to do because these are two different applicants. If you're trying to make an application appointment for the same individual for two different visas, that might be problematic. I don't see why not. Can we travel to India while we are on OPT? Yes, if you have been maintaining status and you have a visa stamp. Can you shift position within your organization when they are filing for your green card labor? That's a very long question. That is not a question I can answer in the time that I have here. We've answered it many times. Look at my frequently asked questions. You will find your answer. Frequently asked questions, blog, these answers are there. The general rule is your substantially same job description is required in order to continue the green card. Okay, guys, I see people are raising hands. I'm not sure what is going on, but when I start talking, it's a new question. So I'm going to wait until I finish my questions. B. Sundar, if you are on the phone, press *5. B. Sundar, press *5 if you're on the phone. And you have a follow-up question? Okay. Let's go on to the next one. Krishna 3CK. Started master's in summer as H4 student. Got the I-20, applied for H4 in June 2015. Started fall again as H4 student. H4 to F1 change of status approved on October 10th. So fall 25-15 considered as F1. To get OPT eligibility, I should study spring to April plus summer. Or if I come, okay, I think it's 9 months, isn't it? 9 months. So, and I believe that when your F1 change of status is approved, this is something you'll have to check with your international students office, and they should actually confirm it with USCIS. But I think the rule is 9 months in order to get for you to get OPT. The only question is the period in which your change of status was approved, would that be counted as F1? And I think that depends upon the date of approval. Okay, so my answer to you is your answer will come from DSO and USCIS directly. Krishna, if you are on the phone, press *5. But this is all the information I have for you. *5, Krishna. Okay. Ajay Kumar says, I have an approved I-140 with A. I left, joined employer B. I want to go back to A. They still have my I-140. Will there be any issues when filing 485? Yeah, there can be two issues. One, why did you leave if the job was permanent? Normally, they don't ask that question. But more importantly, does the employer have the ability to pay you wages even while you were gone? That's something you should discuss with your lawyers. It's a very specific question that relates to the facts of your case. Okay. What if employer A did not revoke my H-1B for 6 months and will meet the minimum LCA wage for that year? Do I have to file a transfer to employer A? Can I use old H-1B? I believe you have to file for H-1B transfer again, to the best of my knowledge. Okay. Revoke my H-1B, use existing H-1B. I think you should file a transfer over to the old employer. That H-1 should have been revoked when you left. If H-1B has changed location in 2014 and LCA was filed for new location got approved, matter of simio, does petitioner have to amend his H-1B? You have to amend the H-1B if the move was in a location more than normal distance away, or if the job description changed or the client changed. So an amendment must be done. Okay. Ajay, are you on the phone? Press *5 if you're on the phone. *5. Okay. Okay, you are here. Let's see. Somebody from California, go ahead, please.
Hi, Rajiv. So I have a quick question. So, technically, since I moved to employer B now, if I have to go back to employer A, so you're saying that he has to revoke the old H1.
Okay, let me interrupt you for a second. Up till about 4 or 5 years ago, if this scene had presented itself, it was the generally accepted legal opinion that if the old employer had not revoked the H1, you could go back and join them without having to redo the H1. However, a few years ago, USCIS definitively said if an employee leaves an employer, they must revoke the H1. It is a legal requirement. If they don't, they must continue to pay the salary. Okay. So in light of that very clear stand, I think the safest thing is to apply for the H1 again. This is a gray area of the law. Nobody can give you a bright line rule, but our job as lawyers is to keep you out of trouble as much as possible. So rather than being adjudicated as being out of status a few months or years down the line, I would rather have it out with USCIS right now. You can also have your lawyers call USCIS customer service and see if they can get a better answer than I've given you. Okay?
Okay, thank you.
Good luck. All right. Next is New York 1021. Mom filed green card for brother and his family in October. Brother lives in India. And then there was a death. So the question is, can we do humanitarian reinstatement? I'm sorry, your mom passed away, okay. She was the one who had filed for mother. Yeah, I think USCIS may be wrong in this, and I think your lawyer may be right. I haven't specifically researched this issue, but I think there is a section of law, what is it called, 304L or something like that. We have some information on that on our website. If you go to our homepage, you should be able to get that information. They are called survivor benefits. Survivor benefits. So I think for survivor benefits, the beneficiary has to be living in the US. So then you can have a substitution of beneficiaries, a substitution of petitioners. Otherwise, humanitarian reinstatement is the only choice, and I think your lawyer is right. As to what my suggestions are, I would have to research this issue. I do not know the answer off the top of my head. Okay, *5 if you have questions more than I have answered. *5 if you are here, New York 1021, or New York actually 10121. Okay. NC01 or 01, I am on H-1B visa. I-140 is approved with company A. I am planning to join full-time with company B. Can I keep my actual priority date? And the answer is, as of today, yes. Tomorrow, I don't know. You should go to my blog. I keep that updated. We have an entry on this issue. Wife is on H-4 EAD. Will there be any impact? No. As long as you maintain status and an I-140 is approved, you will be able to have her continue on the H-4 EAD. How much time for I-140 approval? You can always file premium processing, but it can take a few months, and then depends upon the RFE. Oh, yeah, before I go forward. NC01, if you're here, press *5. Okay. Let's go on to the next question. And I think this is the, no, I have a couple more after that. So H-4 to F-1 visa conversion, how much should be the maximum distance between home and college? If the college is just once in a month and we attend classes, distance is not the limit. The bottom line here is, as long as you're actually attending the classes as required, I don't care about the distance. Okay. And about the CPT, I have written an article. That's the latest article on my blog. So go and read that before you ask this question. Read those questions. Okay. I actually have covered these issues. So go and read my blog. And if you still have some follow-up questions and something is not clear, go ahead and ask me again in 2 weeks. We'll talk about it. But CPT and all, there are certain requirements. I have listed them, 4 or 5 things that the government looks for. Credentialing, whether the program is whether the practical training is integral, whether there was a cooperative agreement signed with the employer by the university. So read those requirements, okay? Can an H-1 person start a green card process? They all do. I don't know what that question means. Everybody who's on H-1 is doing their green card. You know, that's normal. If you're on the phone, Nityanand, please press *5 if you're on the phone. Okay. Tennessee, go ahead, please.
Hi, this is Nitin here. My question is regarding the college and the state that you answered. If we attend the college regularly, that is fine. But only the thing is, I just want to know about the states. Can we have our college in different states and we can stay in different?
Yeah, as long as you are actually attending as required by law, I don't see any problem with it.
Okay.
By the way, I am bringing on the screen our website, and if you look at immigration.com and go on the right-hand side panel, you'll see my blog at the bottom right. Okay, right at the bottom right. I'm highlighting it, and you'll see all these issues. The very first entry is issues including change of status for CPT OPT students. This is a very common issue, so I actually covered it with the sample RFE that you will get during the H1 process. So please read that up, okay?
Yeah, my second question was like, I'm on H1 and I filed H4 H1 conversion for my wife. So like once we get our H1 approved, and can I start my green card process? Because F1 intention is like no.
Oh yeah.
So now
She should not have a problem with that. You can go ahead. Okay.
I mean, she will get F1. She will get F1, and if
Yeah.
the first
The only time you need to start thinking about is if you are at the I-140 stage. Perm stage, nobody cares. Perm is not green card.
Oh, okay.
Okay. Good luck.
That was my question. Thank you, sir.
You're welcome. You're welcome. Guys, the issue here is dual intent, and dual intent begins when I-140 is filed. Okay, let's go to, this is Rohmal, summary of background, April 20, this is too much information, guys. My head is tired by now. Let's see if I can make sense of this. Let's look at the question first. My STEM OPT expires in April 2016 would be my last chance to apply for H1 if I have to go through the quota. Since I have been through the H1 process before through a different employer, would employer be have to file for a fresh H1? Okay, that makes sense. April 2010 was your first H1. H1 was approved in October 2010, valid till September 2012. You got the visa stamping done. Travel to US for first time for employer A in then September 2012 another extension was applied. December extension approved but not stamped. In 2013 you returned to India. I think you are exempt from the quota, sir. I think you are exempt from the quota, but you have only used it for like 3 years. You have at least 3 years left on your H1. Okay, so you can transfer the petition if you want. They'll have to file a H1 petition, but it won't be under quota. You can transfer that H1 petition. It is not really a transfer, but it's an H1 without having to go through the quota. Okay, star 5, Rohmal, if you're on the phone, star 5. Okay, you're not on the phone. Jeez, we had a lot of questions this time. Lippy 883, working on a telecommuting job for a reputed organization, planning to go to India. So basically, H1 people, Lippy wants to know if H1 people can work from home even though it is not covered by LCA. And my answer is, I don't like that. I actually like to cover an LCA for the home also. So I don't know what my guess for something like this would be. I would want the H1 to be amended if it is more than a normal commuting distance from the approved LCA location. So if your home is too far and you're telecommuting from it, you should do an H1B amendment before you go. That would be my guess. Lippy, if you're on the phone, press star 5. Lippy, if you're on the phone, press star 5. Okay, and this is the last question, then we'll start the new questions. This is Raji 6060. Wife got here first H1B in 2007. She worked on H1B till 2011, then H4 conversion. From 2011 to now, she's on H-4 EAD. From 2011 to date, she's on H4. Now she's on H-4 EAD. If she wants to go back to an H1B, how many years does she have remaining? 2 years. Is she in the quota? My best guess is no. Because if you count from 2007, she's subject to the quota. But I think the government will count from 2011, which is till when she still had H1. So I think then she's within the last 6 years, and I believe she'll be exempt from the quota. Star 5, Raji, if you're here. Raji, star 5. Okay, guys. Star 5 for any questions. I have one question from California already up. Let's see. 1, 2, 3, 4. Okay, folks, if you have a question, raise your hand. I will only answer these 4 questions, nothing else. Okay, 4 it is then. Let's start with, there's a lot of people on the phone. I'm not sure if you have questions. Please raise your hand now so I can kind of budget my time. All right, let's start with in the order when people had logged in. The earliest one first. Star 5. Okay, 5 questions now. This is the last opportunity, guys. I will not do any more after this. Okay. Not that I don't want to, it's just that I'm running out of steam. So let's start with, let's see, the earliest login time, which has been an hour, 7 minutes. So let's start with you. Texas, go ahead, please. Texas. Texas.
Hello, Rajesh. Thanks for the call.
Yes, sir.
I had a quick question around H-1B extension after 6 years. So I have 2 I-140 that are approved. One is EB3 and one is EB2.
Okay.
EB2 is about to get current in, say, Feb 2016 because priority date is March 2008. And if I go for H-1B extension, is it possible for me to use my EB3 to get the extension, or I have to mandate to use EB2?
You can use either one of them.
Okay, there is no mandatory requirement, correct?
There is no requirement that you have to use the one that is becoming current. As long as you have approved I-140s, either one of them can be used.
Perfect. Thank you so much, sir.
You're welcome. Okay. Oh, sorry you had to wait so long, over an hour for this question to be answered, but it is what it is. Okay. Let's go to another one who's been waiting an hour, 5 minutes. Georgia, go ahead, please. Georgia, go ahead. Georgia?
Hi.
Yes, ma'am.
Yeah. Hi, can you hear me?
Yes, ma'am. Go ahead.
Okay. I have come here in J1 visa, and my question is like for a year, and I don't have the 2 years time bond which they have it in the visa. I don't have the home country rule. So can I apply for H1?
Yes.
In the meanwhile, when here?
Yes. Yes. But let me caution you about something. Sometimes, even though the what is that form called these days? 1920 or 2021, whatever that form is called. It used to be called IAP 66. What is it?
Yeah.
1920?
2019.
2019. Okay.
2019.
Yeah, thank you. Even though that form says not subject to 212E, sometimes they can make a mistake. Okay. I would. Do you have your form in front of you, the 2019?
Yes, I do have it.
Okay. Come to the first page around the middle. It will tell you the program number. Tell me, does it begin with G as in girl or P as in Peter?
Okay. You might need to give me 1 second.
Yeah, it will
so
say.
One more thing is I have come here as a manager. Okay. So I have heard that, I have heard that I can actually apply for a green card, but I'm not sure is that.
No, you can apply for an H1 if you are not subject to 212E. No question about it. Go for it. Okay, ma'am.
Hello.
Yeah. Yes, ma'am.
Yeah. So can I? Is there a possibility that coming here in J1 and I heard that within 6 months I can apply for green card, and as my designation is a manager, I come here as a manager. But if the company agrees from from the US, they can also process the green card.
Oh, you're talking about an EB1C green card, right? International manager?
Yes.
Okay.
Yes.
If look, I understand your question now. I think I've understood what the problem is. You are saying I have not come here on L1A. I've come here on J1. Can I still get my green card under that category? The answer is yes, you can. No problem.
We can. So if the company agrees for us to do that,
they can apply for your they can apply for your green card directly from J1. No problem at all.
Okay.
All right.
Yeah.
Good luck.
That is my question. All right.
Good luck, ma'am. And
Thank
thank you for waiting. Some people have waited over an hour, and I'm sorry, I don't know how else to do it. That's why we put down the questions so people can put it in writing. I'll answer it. Anyhow, thank you all for waiting. I still am 1 hour, 7 minutes, 1 hour, or 56 minutes, 29 minutes. Everybody has been waiting. But last 3 questions. Ohio, go ahead, please. Ohio.
Hi, Rajesh. Thanks for giving the opportunity.
My pleasure.
So currently I am on L2 visa with EAD card.
Okay.
And we filed 485 application sometime in September. And this morning I have received my EAD approval, but there is no word on AP.
Okay.
And I wanted to travel on December 6th, that's like 3 days from now, and to attend my sister's marriage. So what would be your advice? Because I have read in a forum that I should not travel until I have my AP with me.
I'll have to look at the law. From what I remember, the Cronin Memorandum, Cronin, C as in Charlie, R-O-N-I-N, Cronin Memorandum of the 1980s only talked about H1 people. They were allowed to travel if they had a visa and no advance parole. I think the same rule applies to L2 people also. Please have it researched. You may be able to travel without the advance parole, without any adverse effect on your 485 if you have an L2 visa stamp.
Yes, I do have L2 visa status
Right.
approved till the next 3 years.
So actually, why don't you stay on the phone? I'll take a couple of minutes, see if I can pull up the Cronin Memorandum, see if it makes an exception for you. So just stay on the phone. I'll try to find the information for you in a couple of minutes. If I'm able to, great. If not, then just have your lawyers look it up. Okay? 1 second. Let me get Canada. Canada, go ahead, please. Canada.
Hello, sir. Good afternoon. Thank you for talking with us.
My pleasure.
Sir, I have EB3 category applying 485 since 2007, and my priority date is 2006 July. How many years till you think so to take to the current priority date?
That is all in the visa bulletin. Whatever the visa bulletin says, you have to kind of extrapolate from there. You're not qualified for EB2, sir. Have you looked at the EB2 category?
EB2 category?
Yeah.
Then I'm outside of Canada, but I need to find employer who willing to sponsor us. Now, old employer don't willing to sponsor me EB2.
Okay. What are your degrees?
I have Bachelor of Commerce, and then after I study Cisco networking courses.
Okay,
many,
no.
And I am certified.
You have a 3-year degree. You're not going to be able to get EB2. So no, that's not even worth trying.
No.
Okay, so I cannot assess the time. All I can say is it's going to take the time it takes. Okay?
Okay, sir. Thank you so
You're
much.
welcome. You're welcome. Okay, California. Go ahead, California.
My I-485 is approved, and H1 is valid.
I'm sorry, you are breaking up. I heard your I-140 is approved. Then what?
Yes, and H1 visa, H1 petition is valid until February 2017, and I have completed 6 years. I probably will lose my job in a few weeks. So after my job ends, if I file a visitor visa and continue searching for a job, and I find a job in 2 months, my employer might revoke the I-140. In that case, can the new employer file a H-1B extension based on the earlier I-140 approved?
Okay, let me paraphrase your question. Your question is this. can employer Y file for an H1 extension based upon an I-140 approved through employer X? Is that your question?
Yes, can the next employer file a H1B extension based on the employer B that I want to that will be
Isn't that,
invoked by the
hang on,
employer?
hang on. Just answer my question, yes or no. Is your question not this? If my I-140 is approved through one employer, can another employer file for H1 extension? Is that your question?
No, so that is not my question.
Oh, I'm sorry. Then I don't understand. What are you asking?
Okay. If my current employer A revokes my I-140 after the job ends with them,
Ah, okay.
and then in that case, can another employer file a H1B extension
No,
for a
No.
new job that I find with them?
no, they cannot. I had a very interesting case decided last week where, let me take a hypothetical. Somebody in your situation had an H1 approval till 2016. Okay. Then when they left the employer, the old employer revoked the I-140. When they came to us, I said, I can try this. I cannot get an extension, but I can try getting H1 for 2016, the original approval. They actually gave it to me, even though the I-140 was revoked. You can try that. If there is time remaining on the original case, you can try getting an extension to that date, but you're not going to be able to get any further extension if the I-140 has been revoked. Okay?
So can you repeat the last line that you said? I can
You can try to get extension for the time that is remaining, or transfer for the time that is remaining, but you're not going to be able to get any new time. Okay.
Oh, okay.
When does your hang on?
to-
Yeah, one second. One quick question. When does your current I-94 expire? When does your current H1 expire?
My H1 expires in Feb 2017.
Right. So you can try to argue with the government to give you till 2017 Feb, but you won't be able to go beyond that. I got somebody in this situation in H1. I didn't think I would be able to, but I got it. I don't know if that was an error, but certainly that is worth trying. Okay.
Okay.
Good luck.
Thank you.
You're welcome. Okay. Last question for the day, also from California. California, go ahead, please.
Rajiji, I came here on L1 visa and later converted to H1B visa with a different company, and currently my 140 got approved. Can I apply for 485 when it is current without going for an H1B visa stamping to India?
I'm assuming that you have an I-94 on your H1, don't you?
Yes, I do have that.
So if you got change of status, that means you're in valid status. And your I-140 was approved through the same employer who got you your H1, right?
Yes, that's right.
Yeah, you do not need a visa stamp. You can apply for a 485 directly.
Okay, so even until I get my green card, I can stay here without going for H1.
That is correct. Yes, sir.
Oh,
okay. When does your H1 expire? Let me get one thing clear. When does your H1 expire?
It's in April 2017.
Okay, so you have plenty of time. Yeah. If your dates are current, you can file 485, no problem.
Thank you.
You're welcome. Good luck. Guys, rest of you can hang up. We are done for the call today. Thank you all very much. I am still going to talk with one gentleman from Ohio. Ohio, why don't you call me in the office? Write down my phone number, 703
Sure.
703-908 4800 extension 110. 703-908 4800 extension 110. Let me take a quick look at the law. Maybe I can fix this up for you. Okay?
Sure.
please.
Call me right away. Good luck, guys. Thank you all for being here. I'll see you in 2 weeks.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.